I want to talk a little bit today about the earmarking doctrine. The earmarking defense is a judge-made equitable defense to a preference clawback. What that means is that it's not in the bankruptcy code, but judges decided it would be unjust to force a creditor to return funds under certain circumstances. The prototypical clawback involving the earmarking defense is a transaction that looks a little bit like this. The debtor owes money to an old creditor, call them old creditor, let's say a bank. The new creditor is a guarantor, let's say, of the debtor's debt and decides to loan the debtor money specifically to pay back the old creditor. New creditor specifically directs and requires that the debtor use the new money supplied by new creditor to pay old creditor. The debtor actually uses that money to pay the old creditor. The new creditor essentially replaces the old creditor, and the debtor's indebtedness does not increase, just a new creditor. All that happens is that a new creditor takes over the old debt. Let's say this all happens in the preference period. Assuming that the debtor was insolvent and no other defenses are present, the trustee will argue that the old creditor got a preference, needs to return the money, needs to return the funds to the bankruptcy estate. It was payment of an antecedent debt during the preference period. The old creditor argues you need to look beyond the forms and looking at the substance and taking a holistic look at the transaction, or a series of transactions. Then all that happened was that a new creditor was substituted for an old creditor. The estate did not actually have a net loss or outflow of funds. Given those facts, old creditor argues, it would be unfair to apply the law robotically. No damage is done, no impact on the estate, and no reason to apply the draconian and dreaded preference laws, at least against old creditor. The judge agrees in this, let's say the judge agrees and gives the bank a pass. However, 500 other unsecured creditors are forced to return payments received, let's say 500 or whatever number, are forced to return big preference payments, and they might wonder whether this is all very fair. Also, unsecured creditors are paid a lot less because a creditor who was paid while the debtor was insolvent, at a time when the company could not pay all creditors, gets away with 100% payment, while the rest of the unsecured creditors get paid 3 cents on the dollar in addition to being sued for preferences. So it does hurt other creditors because there's less money in the piggy bank for everybody. So is this fair? Judges are faced with a dilemma of applying the preference law strictly and predictably in the same way to all parties, or to make exceptions when looking at the big picture seems more fair. The way courts have dealt with this situation is to apply the earmarking doctrine only when it seems fair to do so, and restricting the application to only a limited situation and fact patterns. The problem is that judges disagree on when the earmarking doctrine should be applied and the legal justifications for applying it. So we don't have clear precedent because everybody's got an opinion. 2 lines of cases have developed on the circuit level to give some guidance. The first line is exemplified by Manchester versus First Bank. It's a 2000 10th Circuit case, and the cases that follow it abide by the same principle. These judges restrict the application of the earmarking doctrine only to situations where new creditor guaranteed the debt of old creditor. The rationale is if the doctrine were not applied, the new creditor would be unfairly damaged, since if the payment to old creditor were clawed back, new creditor who used its money theoretically to pay old creditor would still need to pay the debtor on its own guarantee. The second line of cases is not as restrictive. These judges apply a so-called control test. Unfortunately, control is never really defined. The theory is that if the debtor did not have control of the funds, then it seems more like a mere conduit for new creditors' funds, and those funds should not be considered as ever coming into the bankruptcy estate, ever belonging to the debtor. Seminal cases for the second line is Bolin Enterprises, 1988, Eighth Circuit case. In that case, the court listed three determinative factors, which are often cited. Number one, whether there was a written agreement that the funds from new creditor would be used only to pay old creditor. Two, whether that agreement was followed. And three, whether there was any diminution of the estate. In that case, the application of the earmarking doctrine was denied because the debtor did not disperse the funds immediately to old creditor and did not disperse all the funds. It did not seem to be. It seemed like it was property of the estate. What has developed is essentially a test of control that doesn't really work that well because every judge has a different definition. Could the debtor do whatever it wished to with the funds from new creditor, or was it bound either by the intention of the parties, which is not being legally bound, or by a contract that legally binds the debtor to disperse the funds to old creditor? The case law has provided very few clear definitions of control. Some courts have required a writing and others have not. Some courts have required that the funds have been transmitted directly to the old creditor from the new creditor, and others don't have that requirement. Some have considered circumstantial evidence and the evidence of intention. Others disregard that evidence and insist only a clear binding contract between new creditor and the debtor to use the funds to pay old creditor would be relevant. The circuit cases have clashed, but do provide some guidance, at least for a particular circuit and a particular fact pattern. For example, in Adams versus Anderson, Ninth Circuit case from 2000, new creditor wired the money to the debtor, not to the old creditor directly, and the debtor transferred the funds to the old creditor. The Ninth Circuit applied a control test to conclude that the debtor had so little say that the funds could be considered to be outside the debtor's estate, and the debtor denied a clawback. It was irrelevant to the court that the debtor received the funds and deposited the funds in its own bank account. It was irrelevant to the court that the debtor received the funds and deposited the funds in its own bank account and did not segregate the funds. In the Fifth Circuit case of Coral Petroleum, a Fifth Circuit case, again, 1986, the funds were wired to the debtor and then the debtor wired to old creditor. Again, it wasn't a direct wire from new creditor to old creditor, but here there was circumstantial evidence in the form of emails and testimony that made it clear that the intention of the parties was that the debtor was not to have control over the funds proceeds, the loan proceeds, but clearly meant to use them to pay off old creditor. The old creditor bank was allowed to keep the preference, but there was no contract specifically requiring the debtor to pay old creditor. So it's a liberal interpretation of the earmarking doctrine. I said preference because whenever there's a payment during a period of insolvency and one creditor is paid in full, when it's impossible that all creditors will be paid in full, then there is a preference. In the Seventh Circuit case of Smith, which is a 1992 case, the new lender lent the money to the debtor with no clear instructions to pay old creditor. Here the court denied the earmarking defense, even though essentially is the same fact pattern, and the money did go to pay old creditor, but the defense was denied as a conservative approach. In Buckwild Capital Advisors, another conservative case, 2006 Southern District, this is bankruptcy court level, a construction manager wrote a joint check to a general contractor and a subcontractor, clearly intending, obviously, that the general contractor should use the money to pay the subcontractor. The court declined to apply the earmarking doctrine because the fact pattern did not involve a loan. So that's a very narrow interpretation. The takeaway from this video is that just because it looks like the earmarking defense should apply does not mean a particular court will apply it. The circuits disagree. The precedent, even in each circuit, is unclear because the facts are often distinguishable.